everyone. Thank you for joining us here today for this conversation about the UPC. The UPC is turning one. It's 1 year old, and we've got a lot to cover. Joining us here today, we have Tobias Wuttke, and he is a partner with Bardehle Pagenberg, and I hope I did that pronunciation justice. Tobias is a partner there. He's become a friend over the years. It's always good to see him, and we're shooting this live in IPWatchdog Studios. Thank you for making the trip while you're here in America, Tobias. It's good to see you.
Thank you for having me, Gene. It's a great honor and pleasure, and I look forward to today's discussion. There's a lot of ground to cover, and I have a lot of news to break.
There is a lot of ground to cover, and what I want to just let people know is Tobias and his firm do a lot of work at the UPC. They also litigate in Germany as well, German courts. But they have 20% of the market share for UPC cases so far. So we're hearing this today from one of the leading firms, maybe the leading firm in all of Europe. So it's a pleasure to have you here, my friend. And what I probably should do is, like I do all these, is just ask you an open-ended question to get us started. And then we can go through and talk about some of the specific issues that we want to make sure we cover over the next time we have together. So what do you tell people when they come to you today and ask you about the UPC, looking back on the last year and maybe with an eye towards what you think is ahead? What general advice do you give companies, for example?
Yeah, the general advice is the UPC is reality. It is a major factor when it comes to global patent litigation, for the simple reason that you have the option to get a court decision for 17 EU states. You reach almost as many people like in the United States. And in so far for risk management, it is just a must to consider the UPC and the unitary patent that goes hand in hand. It's point number one. So you cannot ignore it and have a sit and wait approach. Second point is that the judges of this UPC, they behave like parents with a baby. They are really caring, committed, and they want to make it a success. Also, I think for their personal careers, they want to make that a success, and that could be a self-fulfilling prophecy at the end of the day. We are 1 year into the UPC, and we touch upon that later. The first judgments in the main actions will be out in the next 2 to 6 months. And then it's maybe time to make a review about statistics, how patentee-friendly or unpatentee-friendly the system really is.
Yeah, so if you haven't been paying attention, now is a good time to start paying attention. Because, well, maybe we should just go through the statistics. We had a chance to talk a little bit about the statistics, but people are using it, and they're increasingly using the UPC, correct?
That's true. Each month, between 10 and 20 new infringement actions are coming in. And so the UPC is building up momentum. End of April, and these are the last official statistics that are out, we had 123 pending infringement actions. So independent infringement actions. And now the question is this a low figure? Is it higher than expected? Or is it a high figure? And I think the answer and the truth is in the middle. So it's a 3-digit figure, and it's a figure that is continuously growing. And we have users from all over the world. And I think it's still noticeable and worth stressing. The most frequent user of the new system is a Japanese company. Who would have placed a bet on that? Panasonic is still the most active.
Panasonic, wow. Yeah, no, and when you think about the most litigious Japanese companies, I mean, I suppose they come to mind, but you wouldn't necessarily expect them to be number one.
Absolutely not. And insofar, it just shows you they have trust in the system. It's because of the judges. And also we see all fields of technology. We have life sciences cases, we have pharma cases. So it's not only the high-tech sector which is fighting at the UPC. And users from all over the world, in the end, you could say the only continent that is missing out a little bit is Europe.
Yeah. Yeah, and it is funny. I mean, because when you look at the map of the UPC, it kind of goes across like a stripe going down. It leaves off the UK and it leaves off some of southern Europe. But there are 17 countries in now, and there's a belief that you'll get up to, 25 eventually?
Yeah, belief. So, interestingly, Romania is about to join the UPC land, how I always call it.
Yeah.
And so UPC land might have 18 members by the end of the year. And then will it further expand? Not so rapidly. As you know, there was there is a referendum in Ireland, and whether Ireland should join the UPC or not was originally scheduled for that referendum. The Irish referendum covers other topics, so it would have been a minor side issue. But the political pressure was so high to take it off the list and off the referendum. So the accession of Ireland is postponed. And we all know postponed may well mean it will never happen. And why is that? Because Ireland is a major hub for big tech, pharma. It's their European headquarters. And of course, if Ireland were to join, and that's the reality, each newly granted unitary patent would automatically cover Ireland. And that means you have a completely different risk scenario than nowadays, where only such European traditional bundle patents apply to Ireland, which are validated in Ireland. And I do not know the statistics, but I place a bet it's less than 10%.
Yeah. And Ireland is becoming a little bit like Silicon Valley East. Last time I was there, it was amazing to see Google's buying up block after block and putting up buildings in Dublin and elsewhere around the country. And so that would be a big deal if Ireland were to join. But as you say, I was actually going back and looking at some stuff on IPWatchdog that I wrote, and I wrote literally in 2013 that the UPC was a done deal. It was going to happen within the next 3 to 6 months. Crossing T's, dotting I's, and literally it took another 10 years. But it was amazing that I looked at that article, and if you changed the date 10 years forward, it would have been exactly what wound up happening. So. There has been some dogged determination to get this done. It has crossed the finish line, and now we're starting to see the fruits of the labor. And maybe we can start with there. I know there's a lot of new developments we want to cover, but one of the things in the U.S. at least, one of the things that patent owners always want to know about is, can you get an injunction? And I know we haven't had any final. I think I know we haven't had any final decisions yet. But what is it looking like on the preliminary injunction level?
And for me, it's important because it's a different procedural background. When we talk in Europe and at the UPC about preliminary injunctions, we are talking about independent procedure, a procedure different from the main action. So it's not a step in the main action. First you get interim relief and then you get permanent relief. No, we are talking about basically two tracks. The fast track, which is the preliminary injunction track, and in parallel thereto, you can have the main action. And so independent tracks. So that's important for me. And now if we look at the fast track, and can you get a preliminary injunction? And the answer is yes. We have precedents now. And for the main actions, so the standard track, can you get permanent injunctions? And the answer is Yes, but we have no decision yet handed down. In the main actions, we are now waiting for the first judgments to be handed down. The big thing for US users is, will it be a system of automatic injunctions? And the answer is very likely yes. There will be no real eBay test. There is, of course, in the law a discretion of the UPC to grant the injunction, but everything what's commented on in conferences and if you talk to judges, you get the feel it will be an automatic injunction system with some exceptional scenarios where the automatic injunction may be watered down by a use-up period. Imagine, for example, a pharma case where a certain drug, which is important for certain patients, is patented, and basically you would need time to switch over these patients to the drug, which is from the innovator, and that there may be a use-up period in that regard.
No judge anywhere is going to say, oh, patient who needs this tomorrow, you can't have it because of a patent injunction. So
there may be other scenarios, but just what I want to say, I think the expectation at least is, there's no proof, it's just a prediction, is it will be an automatic injunction system with limited exceptions.
Okay. So we have already had some preliminary injunctions in the system. Can you tell us a little bit about that, and maybe just so people can understand, maybe compare it to what goes on in Germany?
Absolutely.
More or less, better, easier?
Yeah. So first of all, we have in the fast track preliminary injunction proceedings, we have seen injunctions based on the new unitary patent and also on the classical European bundle patent. So that's important. And we have also Court of Appeals decisions in 2 cases. And we have now a test. And the test is more likely than not, preponderance of evidence. That's, at first glance, a very generous test for IP owners. So it must be more likely than not that the patentee is entitled to bring the case. So the registered patentee is, for example. It must be more likely than not that the patent is infringed. It must be more likely than not that the patent is valid. Regarding urgency, do you need to show irreparable harm? Do you need to show that you acted very swiftly once you've learned about the infringement? So the time perspective, the rules of procedure just say you shall not act with unreasonable delay. So you see, it's a rather generous concept. Then irreparable harm, yes, also for these interim relief cases, there will be a weighing of interest. There is a discretion whether to issue the injunction or not. However, from what I've personally learned in the cases I handled, the judges are very much focused on infringement and validity, and the weighing of interests in the end is a certain sideshow. But it's not decisive really for the outcome of the cases. That's my personal view, how I have understood the comments in the oral hearings.
Yeah. So, but there have been injunctions, preliminary injunctions. Or is it half, more than half, less than half?
It's less than half for the time being. Some cases are not finally decided for various reasons. What can be said, trade shows, that's a real scenario for a preliminary injunction. Why? Because in many cases it's a unique window of opportunity to serve up on a defendant who is located in a territory where the process of service takes a year or more. So if he's at a trade show, that's your chance to get hold of the evidence and also to serve. That's important.
Well, and also to stop the damage, right? Because, so many deals are going to get done at these trade shows. And if they're not closed, they're at least opened, and they will be closed because of the trade show. Yeah. So, that is always something that is very important for people just to take into account all around the world, I think. But let me ask you this with respect to, so it sounds to me like you want to treat if you want injunctive relief, particularly if you want preliminary injunctive relief, you want to treat your unitary patent almost like it's a trademark. You want to, where you run with a trademark litigation, you really almost run to the courthouse and say, hey, they're using this, it's causing us damage. Because in the trademark world, you actually don't want to ever get damage. You don't, because repairing damage to your name and trademark and brand can take years, if not longer. So there is an urgency akin to that. It sounds like. Is that fair?
It's actually the whole background of our preliminary injunction system in Europe. We have a European enforcement directive, so that's kind of the guideline for issuing preliminary injunctions, and that directive, it's EU law, basically is applicable to all intellectual property rights. Mm-hmm. And as you just mentioned, in the trademark world, preliminary injunctions are kind of a standard measure. Yeah. And so there is no reason to discriminate patents over trademarks. That's the concept in the mindset of the judges. And that's the reason why Germany and also the Netherlands, Italy, continental Europe has a culture of issuing preliminary injunctions also in the patent world, because we treat each intellectual property right from the outset identical.
Yeah, and it makes some sense, right? Because, you know, if it takes you several years to get to the courthouse, well, then it obviously wasn't, you don't need it stopped yesterday. Mm-hmm. You know, because there was a lot of yesterdays between when you knew about it and when you actually showed up at the courthouse. So, I mean, I guess that does make a lot of sense to factor that into whether or not you get an preliminary injunction at least or not.
Yeah. So again, the irreparable harm, it's a factor, but it's not a decisive factor. Yeah. What it's very worthwhile mentioning is the UPC is really prepared to act swiftly. That's, to me, that's beyond my expectations, because the trade show preliminary injunctions were issued within a day or two. Mm-hmm. So just on time.
That's pretty quick.
That's quick for a newly established court. And why is that? Because the caring parents, they want to make sure the system is a success, and the UPC judges are working on weekends. Mm-hmm. They really put in a lot of time and effort to make that system work. They are determined to make it a success. That's really behind it. And so that's for me important. The system works. It's more like when you then enforce the UPC decision, you need a bailiff, and then the bailiff looks at this decision, which is not sealed, and says, what is this? Yeah. And then you better explain in advance that something is coming and what this new court is. Yeah. And so the early days. Yeah.
So everybody knows. Yeah. So you've talked about how quickly they act, and I know one of the things that was talked about leading up to its launching was that there were going to be pretty strict timelines. Has the UPC lived up to those timelines and the predictions of it being a fast-moving court across the board?
Yeah. The bad news for U.S. users is Thanksgiving is no reason for a term extension. So be careful what you wish for. Yeah,
and the rest of the world doesn't celebrate the 4th of July either.
I know.
Right.
But what I want to say is Christmas is also no reason for term extension. And the Easter break is neither a reason for term extension. What does that mean? The rules of procedure, so the backbone of the system in the end, says in its preamble, within a year, a case on validity, and that's important, the UPC language and slang is revocation. I know you don't use that term in the US. So revocation means validity. Yeah. And the term to trial for infringement is 1 year. So that's the mission statement. And when we now look at the cases that were filed last year on June 1, when the courthouse opened, there were 19 cases. I myself brought 7 to the courthouse on that day. And you could say it's between 12 and 15 months, to be honest. So there's a slight delay in it, process of service and other reasons. but only a slight delay. Apart from that, they live up to the promise, 1 year promise, and term extensions, you really only get those in exceptional cases, and if you get them, maybe 3 days, maybe a week, but not like in the German system where sometimes you ask for 2 or 3 months and you say, oh, the oral hearing is only next year, so please be generous, there's no delay. Yeah. So these times are over. And when I travel, I have my gown with me. And my wife always asks me, Tobias, we are going on vacation. What are you doing with your gown? You're not coming with me. And I say, yes, I'm coming. But we have a lot of oral hearings for interim conference and so on. And they expect you to attend wherever you are. So I did these oral hearings from a hotel room in Tokyo, from a campsite in France, from everywhere. Yeah. So the UPC takes that serious, the deadlines. And it works. It's an advantage in the beginning for the patentee, for the plaintiff, because he has time to prepare his case, right?
Right.
And then the defendant has only 3 months to prepare the defense, to find non-infringement arguments, to retain the right experts, to do the searches, to prepare the invalidity arguments. 3 months, that's not a lot. And now if we look, imagine that you are served with such a complaint on August 1. If you are a European defendant, and if it's an Italian, French, or German one, in August, people are on vacation. Yeah. And you will not believe it, for 3 or 4 weeks.
Yeah. So there is this timing aspect. And I wonder, how has that also affected settlement? Because when I was litigating cases, you never really get serious about settling usually until there's a deadline for something, with each new deadline that doesn't move, that the court doesn't allow to move, there's usually more heightened sense of importance about at least kicking the tires on settlement. I would think across this, without being able to move dates in 12 months, that would encourage people to take that opportunity seriously. Does it?
It's a very important question you bring up. And I was asked that question many times. Is there already a settlement culture? Yeah? Like we have it in the US, like we had it in Germany. And the answer is no. It's premature. We have one case that settled early on, but as far as I'm aware, all other cases are just on track. And that means you will not get a very early settlement, at least now in this early phase. And my personal feeling is people took a risk to bring the case to this new court. Yeah? Mm-hmm. They planned that ahead. They made a certain investment in that. And now, of course, they want to see how that plays out.
Well, right. And I guess as you were answering, I was thinking to myself, this is probably because there's been no real substantive decisions yet, or at least substantive final decisions. There have been probably some decisions on various issues that arise in cases, but we're going to start to see those substantive final decisions come out, and then maybe once we see those, then maybe that settlement culture will start to develop.
There would be a logical point in time. You have the UPC main action, so the standard track, not the fast track. The procedure, 12 months until trial, is divided in 3 phases: the written phase, the interim conference, and the trial, so the oral hearing. Mm-hmm. And the written phase, that's certainly not the standard scenario where you would settle, because the arguments have not been exchanged. But then at the interim conference, that's handled by the judge rapporteur. That's one of the 4 judges. I come to that why it's 4 judges, who is kind of the master of the written procedure and the interim conference, and only then the whole panel is involved. He provides can provide his preliminary opinion on the case. And imagine if he comes into the interim conference saying, for claim construction, this is clear to me, and evidence, no questions, and validity, document D1 seems to be the strongest attack. It's not anticipation, maybe obviousness. Okay, so that's how we see it. Then, as a defendant, okay, it's time to think about a design around, work around,
or something.
Because and that could be a logical point in time, but the culture to provide a clear preliminary opinion, That's a German culture. For example, a French judge would never do that. It's completely against their background and their national practice. And so depending on how clear these opinions or court informations are, then maybe the more likely a settlement is at that point in time.
So I'm never going to be a judge, I don't think. But if I were a judge, I would want to try and encourage settlement. I think, when I was younger, I did I clerked for a judge and then also practiced in litigating. And judges would take a little bit, in the U.S., take a little bit more, and I don't know that they do this today in patent cases, but they would take a little bit more interest in, asking questions and maybe trying to see if the case could settle, and not that they would be involved in the mediation of it and what have you. But I had the one judge I clerked for, he told me that if I make a decision, I run the risk of making everybody upset, because I might give the patent owner something that I think is important but that they don't think is particularly important. And I might agree with the defendant on an issue that I think is important for them but that they don't think is their top important. So he always really tried to encourage them to settle because then at least it's something that everybody can live with.
And you wouldn't have to pen down a decision that would save you a lot of work.
And there's no chance of being overruled.
That's also true. Frankly speaking, and that brings us back to cultural backgrounds. And that's is important really to understand our system. And we come to transparency later. And next topic should be the technical qualified judge. But again, cultural background. How do you become a judge? And who are the judges at the UPC? In Germany, you go to law school. Then you graduate. Then you clerk. And then you are appointed a judge. That means typically you've never worked in private practice and you've never worked in-house in a company. You don't know what the business thinks. So, and that applies to the legally qualified judges, the German ones and the French ones. In Dutch practice, it's a bit different. So that's also an influence we see at the Unified Patent Court. We have people who are legally qualified judges who have been in private practice. And now we have a new animal in the zoo. We have a technically qualified judge. You may have heard about that.
Yes, and I know one of them. And I'm anxious to ask you this question because you told me that you'd be willing to answer, but you kind of didn't tell me what your answer would be. So I'm anxious to hear what you're going to say. Is the technically qualified judge, do you see that as an advantage for the patent owner or an advantage for the defendant?
Yeah.
And then maybe before you even answer that, they're not in every case, right? So how do you get a technically qualified judge assigned to your case?
Mm-hmm. Okay. First of all, it's good for justice that such a person is on a panel. And what really happens, this guy will filter out cases, which are weak and where maybe a plaintiff tries to misguide the judge what the technology really is about. And so it's ensured by the technically qualified judge that crap cases are filtered out. That's important. And so far, I think it's good that he is there. He ensures that the legally qualified judges are not misled. And who appoints these technically qualified judges? They are not there initially. Initially, at the local divisions, you have 3 legally qualified judges. And if you litigate where 95% of all parties litigate in Germany, France, Italy, and the Netherlands, you have 2 national judges. That means 2 German ones, 2 Italian ones, 2 French ones, 2 Dutch ones, and 1 international judge, 1 legally qualified judge from the pool of judges who is assigned on a case-by-case basis. Mm-hmm. So that's the initial setup of a local division. And now there's a 4th judge, the technically qualified judge, who can be brought to the panel up on the request of either parties. And I have seen now plaintiffs asking for a technically qualified judge. That shows you it's not perceived as the defendant's angel. Mm-hmm. And you know now again, how is the new system? The Unified Patent Court has a unified procedure. That means in the infringement action, you have a counterclaim for invalidity. Again, terminology, we call it the counterclaim for revocation. So it's not the German system where we bifurcate infringement at the civil court and invalidity at the federal patents court. It's a unified procedure. And in the moment you have a counterclaim for revocation, you must have a technically qualified judge on the panel. And so in almost every case we have now a technically qualified judge. Even in our fast-track preliminary injunction procedures, they play a role. And what does it really mean? It means that in the UPC cases, you better prepare the technical arguments well. You have a technical mind. That means private expert opinions play a huge role if you want to show what the common general knowledge was at a point in time. That will play a much bigger importance than in national litigation, because if you talk to a legally qualified person what the common general knowledge was, he may start, yeah, it's interesting, but now let's look at claim construction. And so far the procedure has changed, and yeah.
So that's interesting. I mean, it'll be interesting to see what winds up happening in terms of winners and losers, and is there a technically qualified judge present or that sort of thing. And we'll have to have those conversations the next time you come back, because by then we'll have enough decisions that we could probably look at. So we're still kind of, I guess, trying to guess. But what we actually we're here right now, so maybe what I'll just do is I'll ask you about the evidence issues, right? I mean, because there have been some evidentiary rulings and so forth, and there's been discovery going on, and what goes on in the UPC? Because in America, discovery is wide open, like the wild west. And I know in Europe that's not the case, and I suspect the UPC is much more like the European experience. But what have you seen with respect to discovery, evidentiary issues, and so forth?
Okay. Important, we have no discovery like you are used to it in the United States. And now I make a prediction, but I was wrong with Brexit, so it may be the next wrong prediction. We will never have US-style discovery in Europe. And I think that's also important because you at the beginning mentioned, the system that should have started a decade ago, actually over a decade ago. But the rules, they were also fixed at that point in time. So we have to read them and understand them going back in time 10 years. Yeah? That's also important when we discuss transparency. We come to that in a second. So whether you may have a hope to get US-style court docket, access. And now...
well, let's just say right there, I mean, and we can come back to it, but you don't have access to all the documents like you would in the U.S., right? There's not a docket watch or docket availability.
There are now private service providers kind of digesting the information that's out there. But what is the information? It's the name of the parties. In the moment the case was served, then it becomes accessible, but only in the superficial layer. Name of the parties, value of the action, where the case was brought, what is the patent in suit, and you can see what happens in the case. So is a statement of defense filed, a counterclaim for revocation. But if you want to look what is filed or what was filed, you don't get access. So only halfway there. And for the US users, this is frustrating because they are used to a different system.
Right, we're used to seeing everything unless there's a protective order.
But the flip side, you know which patent is litigated. You can check then are other people sued. You can immediately create a joint defense group. You can combine defense strategies. So it's completely different to the German system where you didn't know at all that a case was ongoing. And as a plaintiff, you were not allowed to communicate about the fact that you brought a case. If you did so, you would be directly injuncted under our Lanham Act. So that's a different culture because the file court docket in Germany is confidential. You need a real legal interest to access the file. Accessing the contents of the UPC file, you also need to show a legitimate interest, and it's broader, much broader than in the German concept. For example, we now have an unpublished case law where the UPC held if you have EPO opposition proceedings and you are involved there, you can get access to the UPC invalidity action, so the revocation action, because it's interrelated, even so you are not a party to the UPC proceedings. Yeah? So far, there is limited access, not like in the US. And the idea is also, what is behind it? The culture is privacy. You know, we have data protection, is like the holy cow in Europe. And also, it's seen like you invested your private funds in such a case. So in the end, you own the work product that was filed with the court. That's not for everyone. It's your private investment. So that's behind it. Yeah,
it's a different view of the world than here in the U.S., where everything is open, and that's a longer conversation probably for another day. It is what it is. You don't get what we're used to here in the U.S. And I guess one of the things that I was thinking about is they say you file. You've probably heard this, right? Patent owners are increasingly engaging in this global full court press. You maybe file at the ITC in the U.S., you file in a district court in the U.S., you file in Germany, maybe you file in Brazil, and now the UPC is an opportunity to file as well. And one of the two big reasons to file in the U.S. is you can get U.S. discovery, and then if you're a patent owner, you would like to settle with U.S. damages law as a backdrop, and then you would really want the injunction from Germany or now the UPC as the patent owner, strategically thinking. But the UPC moves pretty fast. I mean, is U.S. discovery even going to keep up with what's going to help you in the UPC, or is U.S. discovery even too slow to have relevance in the UPC action?
Okay, that brings us back to the previous topic we wanted to focus on, namely discovery, production of evidence. Is there an obligation to do so? And now let us look at the angle, which would be a US 1782 discovery request. That means you do discovery in the US for use in a foreign tribunal and under the 4 intel factors, which you would have to argue. And how does this play out? And the clear answer is you need to do that early on. What is really important now is that in the US you have the protective orders, attorney's eyes only. And that was a problem in previous, or is still a problem in German patent litigation, where you cannot kind of present such a solution because at least one person from each party must have access beyond the outside counsel. And now the UPC in 2 cases said, no, if the parties agree, we have attorney's eyes only. And that's, of course, very important because that makes it easier to bring information from the US discovery in UPC proceedings. It would be perfectly legitimate to do so. There are no limits in the rules of procedure saying we would not allow information from US discovery, also witness deposition minutes whatsoever.
It just has to happen fast enough to be relevant.
That's true. Yeah. That's absolutely true. On the other hand, and that is maybe the overall topic. So, the general rule is a party relying on a fact bears the burden of proof. Good. The reversal of the burden of proof, forget about it. In very limited scenarios, there's Article 55 of the UPC agreement, very narrow scope of application. And you can maybe then count on a so-called secondary burden of proof that a judge may say, now this party did everything he could reasonably, the information is not in his sphere of control, so please defendant, now you present your case on that. Can you count on that happening? No, as a plaintiff. There is a duty that you shall truthfully present the facts. And that means, as a defendant, if you just say, oh, the plaintiff was wake, it's not enough. You need to contest, and specifically contest. Yeah? And if you don't contest, it's considered to be undisputed. That's an important general rule. And but still, if it's contested, you bear the burden of proof, and you lose if you cannot prove it. So the question is there a tool where you can force the other party to present information you need to rely upon. And there's a Rule 190 allowing for such an option. But the case law we have seen now from the UPC, it's stemming from the SEP world, that the patentee needs to provide the licenses that he already issued and granted based on that SEP. And but it's crystal clear it's in the discretion how broad that rule is applied. And it's also it's no fishing expedition. So you need to be specific what you would like to see. If you say I want to see everything backwards and all future agreements and also side agreements and whatsoever, you will not get that based on that case law.
Yeah. Interesting. All of this is so interesting, and you guys are dealing with this in the first instance. Really, I mean, with it being a brand new court, how have the judges? Do we even know enough yet to know how they've been influenced from practice and procedure and substantive rules in the courts where they are already judges?
Yeah, the answer is yes, they are, very much so. That means, and that brings us back to the cultural diversity we have. The rules of procedure, for example, they are also a European blend. So, for example, if you look at the rules for the preservation of evidence, so our limited pretrial discovery, that's heavily influenced by French practice. And that means also what we see from the first UPC case law, where were these cases brought? They were brought in Paris. They were brought in Brussels because Belgium has the same system, and in Italy because Italy has a very similar system, the discrezione. And these judges, they have no other guidance than to apply what they've done in the past.
Right.
And what would you do?
Of course.
It doesn't come out of the blue. Same is happening in Germany, where we have most of the infringement actions pending and also the PI requests. So the German local divisions of the UPC have a market share of 70% plus X. That's significant. And they also start off the cases with their traditional German thinking. And the Court of Appeals will eventually unify. So that's what will happen.
Yeah, and I would think that will also start to change as these judges, not only as the Court of Appeals does more, but as these judges become full-time, right? Because they're still, most of them are still part-time UPC judges and full-time judges in Germany or full-time judges in France, right?
That's a real challenge. In my mind, that's more than a teething problem of this UPC baby. It's they are overburdening these busy judges, actually. As I mentioned, they're really working on weekends. We get replies on weekends from them. It shouldn't be like that. And they should have the time to look properly at the cases. I mean, that's what we want. And there is now a round of upgrades, but we do not know to what extent judges will be upgraded. But I think there is a need for full-time assignments and also for the technically qualified judges. That's indispensable.
Yeah, everybody I talk to thinks that it's just a matter of time. The question is how much time and how quickly do the judges become full-time? And a lot of that has to do with the caseload. But I don't know that we've said this since we started recording, but you said, I think before we started when we were just chit-chatting, that there's 10 to 20 new cases a month, right?
What are they waiting for?
Right.
I mean, look, we are in a transitional period of 7 years. In that transitional period, for the traditional European bundle patents, you can litigate them both at the national courts and at the UPC. Mm-hmm. In 6 years from now, that's over. There is the theoretical option that they extend the transitional period for another 7 years. I don't see that happening. That means in 6 years from now, it's UPC only.
Right.
And what are they waiting for?
Now's the time to get it right.
And they want to get it right. They want to have good case law from the beginning. I can't understand that investment decision, frankly speaking.
And cases growing that fast.
Absolutely.
It's going to happen sooner or later.
It must happen, and sooner.
It might as well be sooner.
I hope it's sooner. I really hope that.
Yeah, I mean, it would be better for the whole system. So let me. So now one of the other things that we wanted to talk about, make sure we got this in, is the new developments at several of the local divisions. That you mentioned that there's, I think I know that there's something going on in Munich, and is there something also going on in Milan that's worthy of us knowing about?
Yeah. So that brings us back to the question, how is the UPC set up? And we have two independent types of procedure: infringement actions and these invalidity actions. And the infringement actions are handled at the local divisions. We have 13 local divisions, and we have one regional division, but that is also similar to a local division, so handling the infringement action. These central independent invalidity actions are handled by the central division. And the central division was originally in Paris, Munich, and London. Now, because we have Brexit, it's
right.
Paris, Munich. But now we have it also in Milan. And the question is always to which section of the central division will your case go. That depends on the IPC class, or the International Patent Classification, in which your patent was filed. And you can say basically Munich is mechanical and chemical. Milan will be human necessities, and Paris is the rest. So the lion's share is in Paris. And that's the reason we have currently 28 central invalidity actions, 24 in Paris, 4 in Munich. So that shows you Paris has the lion's share. And for the infringement actions, the Munich local division is the clear front runner with 46 out of these 123 cases.
In Munich?
In Munich. And now what happens on the first anniversary of the UPC? This local division gets a second panel. Theoretically, each local division can have multiple panels. Yeah, and now we get a second panel, and now there is some irony to that, because it must be again two German national judges, because it's a German local division, and as I mentioned, France, Italy, Germany, and the Netherlands, you have two national judges. And now we get two super experienced Düsseldorf judges to the second panel of the Munich local division. And that means if you then in the future bring a case to the local division in Munich, which you can do because we don't have TC Heartland case law, you can do forum shopping. Up till now, you could do and judges shopping, because you would exactly know that one of the two German judges would be your judge rapporteur, because the part-time assignments of the international judges basically preclude them from being a judge rapporteur. But now you get a second panel in Munich, and you do not know up in advance whether you go with your case to panel 1 or panel 2. So the Munich or the Munich-Düsseldorf.
Yeah, so it'll be a little bit different, but you'll still know you're getting highly qualified German judges.
But you still get, in the end, unless there's UPC case law, you get German case law for that.
Well, yeah, and you didn't hear this. We did it last week, our patent litigation program here. And actually, Judge Rader was sitting right where you're sitting right now. And somebody asked him, his advice on where to bring cases. And he said one of the two courts he mentioned was Dusseldorf. So it's interesting that you're going to have a sort of a Dusseldorf contingent within the UPC now as well.
Absolutely. I think, frankly speaking, the Düsseldorf was historically the epicenter of patent litigation in Europe. Yeah? I mean, the Düsseldorf court had attracted 500 new cases per year. Yeah. And they had 3 panels, and still have that nowadays. But national litigation, there is a real downturn in continental Europe, at least in Germany. We see the figures are clearly decreasing. And also at the Düsseldorf court and at the Mannheim court. Yeah? And the Munich court is kind of against the trend a little bit. But still, many reasons for that happening. But that the Munich local division attracted more cases than the Düsseldorf local division of the Unified Patent Court, that was certainly something which did not land well with some people.
I bet it was a little bit surprising, but it is what it is, and it's interesting to hear, and not surprising to me that you would have 70% of these cases brought in Germany, because Germany has played for a long time now a very important role in patent dispute resolution and in litigation in particular. So it's good to see that trend is continuing. Maybe, we've been going for a while. There's still a number of topics that we want to cover. One of the topics that always comes up whenever you talk about Germany, we hit on it a little bit, is injunctions. But one of the things that people will say here in the U.S. is like, oh, and I think they're just trying to downplay how important Germany is yeah, you could get an injunction, but you have to pay a bond and all that other, And it's not a concept that's foreign to American litigation either, And if you want an injunction, a bond is, that's sort of the entry price to get it, right?
And it's a bond for a non-final decision. If you have a Court of Appeals decision, you don't need to provide a bond.
Yeah.
These decisions are enforceable on the day they are issued. It's the same with the UPC, by the way. And so we do not know what the bond practice will be at the Unified Patent Court. I expect it will be the balance to the automatic injunction.
Yeah.
And but it means if you wait just 12 months longer, you are still within a 2.5 year time period. That's fast compared to U.S. District Court litigation.
Yeah, absolutely.
You may get a final court decision without the need to place any bond.
Yeah, interesting. So, what have there been any hot topics, legal topics that have been decided so far that you think people should know about?
Yeah, the most important one, but that was left open, and now you say why you're starting off with a topic that was left open by the Court of Appeals, is the file wrapper estoppel. So we had 2 cases where that played a role. And the one case is a Düsseldorf local division case. It's about an avalanche security device. And here the local division in Düsseldorf just copy-pasted former German Supreme Court case law saying, I simplify, forget about the file wrapper. The Munich local division in the case said, yeah, that can be a means, not decisive, but a means for claim construction. How the claim history was, because they said in that case there was an amendment made to the claim, and based on that amendment, the overall context of the claim showed there's a specific meaning to that feature. And that case went to the Court of Appeals, and I think everyone had anticipated the Court of Appeals will now use this opportunity to provide guidance. But that's a PI case, as a fast-track procedure, because we still don't have any first instance decision standard main track. And the Court of Appeals simply said, we do not have to decide on that. And that's a general observation. The Court of Appeals is very shy. We have no obiter. And I think because these are very, very experienced judges, they know also as a judge you need to be careful, because the next case you get could just lie
just a little bit
next to the line you wanted to draw. Yeah, so that's the reason. And it's also, I think, the reason because it was a preliminary injunction fast-track case, and they say if we do things like that, we do that in the main track and not in summary proceedings.
Well, that probably makes a lot of sense, right? Because in a summary proceeding, you're not usually rolling up your sleeves and doing a hardcore claim construction. That's going to come later. What you're trying to do is you're trying to say, is this pretty obviously a win for the patent owner? Is it, and as you said, it's a friendly standard. Is it likely that the patent owner is gonna win?
That's
And with that standard, you don't necessarily have to cross all your T's, dot all your I's. You're kind of looking big picture. What does it look like, right?
And the file wrapper estoppel is probably the hottest potato in the cooking pot, yeah?
Right.
You want to be careful if you put on a glove when you touch it or not, yeah?
It requires the most work, I would think, right? Certainly going through the wrapper to see, when this was said, what did the examiner understand that to mean, and what were you giving up, and, et cetera,
and we still have telephone interviews sometimes, so...
Yeah. Yeah, so that makes sense to me. But it'll be interesting to see when they no longer can dodge answering that question specifically, where they land. Are there any other issues where there has been sort of an inconsistency in rulings so far?
Yeah, that's an important point, and that will show you we are still talking about a startup. Why? We have inconsistent rulings on sideshow issues. Security for costs, whether in a preliminary injunction fast track case there is a cost decision, yes or no. And why is that happening? So the first instance judges, they are talking every fortnight. So there's a judge's corner. Of course, they cannot discuss everything in a 2-hour roundtable webinar style format. But what is lacking is a real database where you just look, Rule 158, what is the case law on that? That will happen. So the UPC invested now into this software, and by the end of the year, you likely have more intelligence than much more than now. Like you can check which are the countries the plaintiffs are coming from, what's the value of the action in the standard case, and so on. But that's not now here. And in so far, if the judges don't check the case law themselves, they have no database where they can just check what a summer clerk could do in a U.S. law firm.
Right. So let me ask you: is that going to be for use by the judges, or is that going to be for use by everyone, including the parties?
That's for use by the judges, but
Right.
they are of course private service providers now building up these databases. But that's really startup. It's the early phase,
Right.
yeah, and
Right.
that's the reason why we sometimes have inconsistencies. Of course, and that's again a cultural thing. And maybe it's frustrating sometimes you as users. Why do these attorneys not exactly know all the decisions and the judges don't care really? We don't have a system of stare decisis. So there is no binding precedent. Mm-hmm. If the local division in Munich says X, the local division in Düsseldorf can say Y. The judges are completely independent. Yeah?
Until the Court of Appeals weighs in.
They weigh in, and here there will be a unifying force, much different than in the German system, because they are only appointed for a 6-year term. German judges have a lifetime appointment. Mm-hmm. Yeah, they are considered state officials, and in our constitution is this lifetime appointment is there that they can be independent.
Mm-hmm. Same here in the U.S.
But at the UPC is a 6-year term, and who knows who will make the appointment decision, and if you kind of
it'll be interesting
deviated from the guidance of the Court of Appeals 1,000 times, maybe they say, okay, guy or lady, please go somewhere else.
Yeah, it'll be interesting to also see whether that means that there will be more of a shifting in philosophy in certain areas as new judges enter and the existing judges term out. That'll be something to watch, I think.
And if Ireland joins, we would have a common law country that may have some influence on the overall system. The rules of procedure have a common law root, so to speak. And there are many aspects of the rules of procedure that come from the UK. But now the UK is out, and that means that influence decreases. Still, and that's also important, the Unified Patent Court is an open court looking at UK decisions. Still, they play a role also for litigation strategies. And I see the day coming when there will be much more respect for US and UPC decisions than there was in the past, maybe for a German and a US decision. So the UPC will have a unifying force.
Yeah, I think that they certainly will. I mean, it's a brave new world, and if you're not paying attention, you really need to be paying attention. And I understand the hesitancy perhaps of some pharmaceutical companies, because it is a little scary. You have one patent that matters far more than any other patent in your portfolio, and a single patent can protect a billion-dollar product, or in some cases multi-billion-dollar product. You lose that one fell swoop in 17 countries. That can be daunting. But for most people, having the ability to get a single patent, lower transaction costs in 17 countries, a single action with the real possibility, even though you said it's a little less than 50% on the preliminary injunction. I mean, we would take that in America. I mean, nobody's asking for preliminary injunctions in the U.S. anymore, because injunctions, you just really You can't. It's hard to even get a permanent injunction in the U.S. So there's a lot of advantages to this system, and as more countries get added on, it's only going to get better.
And in the end, you are sketching out why to apply for a unitary patent.
Absolutely.
And like with this transitional period, the uptake rate of the unitary patent is now 20 plus X%. Yeah? Mm-hmm. We will see, I place a bet, in 6 years from now will be far over 50%. It's simply too attractive. Yeah. And also I see we will get AI tools that say, okay, you need that specification for that UPC case law to match that. And with a unitary patent, kind of you can tailor your spec to the UPC that will have also in that regard a unifying force. Because currently, how do you want to draft your spec? For Dutch case law, for German case law, for French case law?
Right. Yeah, no, it's a big difference. And the other thing too is you're seeing increasingly, this has always been an issue, right? Costs are always an issue. They've always been an issue. But they're much more important maybe now than ever, as portfolios, the size of portfolios have ballooned, the carrying costs have ballooned. So this is a very attractive patent to get, where the carrying costs are not ridiculous. You get it in 17 countries, and the real thing is we're starting to see some first glimpses that the predictions were right. It was going to be, from the U.S. perspective, a much more friendly patent owner court than what you might see in the U.S., for example. If that continues, then it makes it even not only cost savings to get coverage in these 17 big part of Europe, but real advantages from an enforcement aspect as well.
Yeah, what I think they want to be a balanced court. That's, to me, crystal clear. That also shows you that we don't have grant rates for interim relief in the 80s or 90%. They want to appear to be balanced. In particular, in the initial phase, a lot of uncertainty is there. What is also important, however, and I think that's the balance in the system, we have the tough tightlines, an advantage for the patentee. But in the transitional period in particular, you have multiple invalidity attacks. Yeah? If you have a traditional European bundle patent, you have the opposition procedure at the European Patent Office, central attack. You have a counterclaim for revocation, central attack. You have a central revocation action, central attack. And you can also bring nationality actions. So you can really attack the patent from multiple angles, creating a lot of costs. So that's a lot of water in the patentee's wine. Yeah, so that's the balance.
Right.
But still, compared to other systems, and I think.
Yeah, I think it's, again, I've said this before, I'll say it again right here. I've said during this, if you're not paying attention to the UPC, you really need to educate yourself, because it does present some real strategic opportunities for an awful lot of patent owners. So far so good. It's not done anything crazy. It's not a rubber stamp for the patent owner. It's certainly not a rubber stamp for the defendant.
Exactly.
And and that probably means that so far you've struck a pretty good balance.
Yeah, I think that's the overall view, not my personal view, just among practitioners you talk to. I think everyone is happy with the way how the judges approach the new system. Mm-hmm. And I think the judges are also happy to see the way how it works. So I think there will be some champagne glasses on the anniversary. And but maybe the outlook, what will happen in the next year or two?
That was my last question to you. I mean, we've been going for a little bit over an hour, and I appreciate you taking this time. But what is your prediction for maybe the next 6 months as we start to get the decisions, and then maybe also over the next year, so when we come back and we talk about the UPC at 2, what are we going to be talking about?
Predictions, you have to be very careful, because I was so wrong with my prediction as to how many cases would be filed on day 1, on June 1, 2023. So, but what we'll get, now we get the first judgments, and we will then also get the first decisions on damages. And here my prediction is we will not see US-style damage awards. And it's again the cultural thing, because these continental European judges are not used to issue such damage awards. Even if you have more territories and you could say, okay, the turnover is higher from which you calculate something, it's just against their DNA to issue these awards. Yeah, and we will see a lot of experts in these damage award battles, like in the US. There will be a certain industry coming up, and and then hopefully, and I think that's then when the Court of Appeals decides the first cases on the merits on appeal, we need some guidance. File wrapper, doctrine of equivalence, I think these are the two main fields which are currently uncovered.
So keep more to come. Keep your eyes out on those areas. Any other areas of interest to look forward to over the next year, you think?
Yeah, I mean, everyone will be interested to see also the interplay of national cases and UPC cases. So will we see a lot of situations where cases are stayed so that the national courts say, we wait for the UPC, so UPC first. Mm-hmm. How will that play out? Will a national court really deviate from UPC case law? They could, yeah, both for infringement and validity. There is no presidential effect. It's a different law they apply, even if the grounds for invalidity are the same and the concept literal infringement, DOE, is the same. Yeah. So we'll see how
so there's a couple flies potentially in the ointment.
Yeah.
But we'll see. I mean, hopefully that won't happen. Hopefully there'll be an answer. You know, that's one of the problems we have in the U.S. You know, decisions are different from the district court and the PTAB and the ITC and federal circuit, depending on the panel that you get. It just creates so much uncertainty. It's very difficult to live in that space as a patent owner or as a defendant. Although in this environment, it's been a lot easier to live as a defendant in the U.S. because you do a lot more winning than you do as a patent owner in the U.S. A system where it's closer to 50-50 and there is more respect for what the judge who just heard the same case and already did all the work did, I think would be a large step forward for the whole world.
Yeah.
You know, because these disputes are worldwide. You don't settle them on a country by country basis anymore.
That's true.
Unless you're a small player, unless you're a small entity and you have a competitor and you two are only competing within a certain country. But you know, the major companies, they want the settlement has got to be global or it's not worth doing.
Yeah, and that was my point, that now the European judges with the new system started to understand, okay, we have to understand why someone is doing something, what's behind it. Maybe we can adjust, adopt, unify, and maybe we need a global unified patent court one day.
Yeah, we'll see. Well, this is the first step.
Yeah,
you know,
definitely.
Maybe we'll get there. Maybe it's probably a lot to ask for during our careers.
Yeah, I know.
but I think we'll see a much more vibrant UPC year after year, and that's the first step.
Definitely.
Yeah. All right. Thank you very much, Tobias. It's good to see you.
Thank you very much, Gene. It was a great pleasure, and thank you for listening today.
Sure, no problem. So for everyone where you're watching this, we'll make sure that we have tagged Tobias in the description with a link to his bio and his firm. If you have any other questions about the UPC, please feel free to follow up with them. They are the experts in this area, and we're always glad to have them here and to talk to us. So look forward to seeing you again soon, my friend.
Thank you, Gene.
Bye, everybody.